Associated Credit Union. And apparently Chase intended to foreclose in March of 2013 because of the default. I don't know where we are now. Okay, we're right. Okay. Because of the default. And the default had been cured, but Associated Credit Union claims they didn't know that. And they claim that Associated Credit Union claims that in the plaintiff's deposition, the plaintiff admitted that prior to them paying off Chase, he didn't tell Associated Credit Union he brought the Chase loan current. So then it's my understanding that the plaintiff wanted to unwind this. Chase had canceled its security deed because it had been paid off by Associated Credit Union. And the plaintiff had filed a complaint with the Consumer Financial Protection Bureau and wanted to unwind the loan, the payoff. And it seems like Chase claims that it circulated a settlement agreement and the plaintiff rejected it. Is that where we are, basically, that Associated Credit Union paid off Chase and added the Chase amount to its indebtedness, and basically Associated Credit Union has a first lien on the property? Is that where we are now?
That's where we are now, but Your Honor, this is James Deering for the record. With regard to the associated payment, the problem is there was a lack of notice to Dr. Roberts initially before the payment occurred. And there's evidence in the record that we submitted to the court that shows that there's an obligation per the deed to secure debt, as well as evidence that there was conversation, there were some conversations, phone conversations, never written conversations, showing that ACU was going to pay off the Chase loan. So that's where we are.
Is there anything that requires them to do that in writing?
Yes, Your Honor, the deed to secure debt. The deed to secure debt says that they must do so. They must provide notice to the borrower.
But what about the fact that Chase attempted to unwind that and your client rejected the attempts to do that? Is your client admitted in his deposition that he never told the Associated Credit Union that he had brought the loan current? So he's admitted that he told them that. And so, I mean, how is your client harmed? I don't see any harm to, is Mr. Dr. Roberts living in this property?
Yes.
Okay, and there's a loan to Associated Credit Union for the balance of the Chase loan and the Associated Credit Union loan, is that correct?
No, well, this is Catherine Gibson, Your Honor. The client is harmed because the loan terms are totally different at this point. He had to pay more each month. He had a 5% fixed rate with his first mortgage with Chase. They rolled it into an adjustable rate, and it took them over a year to finally decide that they wanted to unwind the transaction.
But was there any legal obligation for them to do that? It sounds like to me. Who represents Chase?
Your Honor, Tom Eisler on behalf of Chase. No, there is no obligation for Chase to unwind this transaction.
And it sounds like to me Chase was trying to do that, and then the plaintiff rejected that offer. Is there any dispute of that, Mr. Deering?
Ms. Gibson was going to answer that portion if she could.
Yes, under any security deed, a borrower has 5 days before the sale to bring their loan current, stop a foreclosure. And Dr. Roberts did that, and the mortgage should have been reinstated as if there was no default. But instead, Chase accepted this payment from ACU and canceled his mortgage.
Now, why would it be unreasonable for a first mortgage holder to accept a payment from a second mortgage holder when the first mortgage holder was about to foreclose on the property. And I mean, is there anything in the documentation that prevents them from saying, hey, you want to take us over? This guy, we're about to foreclose on him. You can have the troubling debt. I mean,
Yes, there's a
Iceland?
paragraph 19 of the security deed gives a borrower 5 days before the sale to pay all sums, cure all the default, pay the expenses, and he did all of that.
Well, now wait a minute. We're talking about different things. The default was cured. Is there any requirement that that JP Morgan Chase Bank, is there anything preventing them from letting Associated Credit Union come over and pay off the loan? I understand the loan was brought current, but is there anything preventing Chase from letting Associated come in and pay them off? The loan was current. Is that correct, Mr.? Is it Isler or Eisler?
Eisler, Your Honor.
Right.
No, you're absolutely right. The language that the plaintiff has cited from the security deed only gives plaintiff the right to have enforcement of the security deed discontinued. It's undisputed that happened, that Chase canceled the foreclosure and returned his loan to normal servicing. There is nothing in the security deed or any other contract that prohibits Chase from accepting a payoff from a junior lien holder. And in fact, Chase provided undisputed testimony that Chase accepts payoffs all the time, even on loans that are not in default. Think about refinancing a home or selling a home where the borrower is not in default. There's nothing in the contract that prohibits Chase from accepting the payoff.
So there's no dispute that this loan was in default. Both loans were in default, the Chase loan and the credit union loan. And I assume the credit union loan was brought current too at the same time?
He was making payments he was communicating, making payments on both. He let them know that he was unemployed for 6 months and that he had just gotten employed. He was communicating with both banks. And so the problem was ACU never told him they intended to pay off the Chase loan. But I want to also correct the record. The reinstatement agreement says that not only will the foreclosure be ceased, but that the parties will go back to strict and complete compliance with the terms of the note and security deed in effect immediately prior to the borrower's default. And when
but we're talking about different things. The loan was current. It was not in default. And counsel for Chase is saying that they accept junior lien holders payouts all the time. And there's nothing in the documentation preventing that. So we're not talking about a loan in default. We're talking about several things. One, that the plaintiff never notified the credit union that he'd made the loan current. But it also appears that the credit union attempted to contact the plaintiff and he never returned their calls or didn't take the call. But let's talk about something else. Why did the plaintiff reject the agreement to unwind the ACU payoff? I mean, it seems like there's some kind of estoppel here. He asked for it to be unwound. They agreed to it, and then he wouldn't sign the settlement. Why is that? What was wrong with the terms and conditions of the unwinding of the credit union payoff? I mean, it appears to me that Chase did that without any legal responsibility to do that. Is that correct, counsel for Chase?
That's correct, Your Honor. There was no obligation for Chase to do this. It researched plaintiff's Consumer Finance Protection Bureau complaint that was filed, in which he requested that everything go back to the way that it was before. And that is exactly what Chase attempted to do in this agreement.
What was communicated from the plaintiff as to why that agreement to unwind was rejected? Why was it rejected, Ms. Gibson and Mr. Deering?
The attorney, at that time, plaintiff had paid a significant amount in additional interest, attorney fees, filed a lawsuit, And so at that point, they were in negotiations because he had waited over 16 months for this transaction to be unwound. And there was no response after asking Chase.
Well, he wanted to have his cake and eat it too. I mean, they agreed to unwind it. They agreed to give him favorable conditions going forward, and he rejected it. It sounds like to me that Chase had every right to let ACU pay it off, and they were trying to do your client a courtesy to unwind it when they didn't have to, and he rejected it. And that's why we're here. I don't see where the plaintiff has any claims, any valid claims against either defendant.
Well, the Court of Appeals, I think the case went up to the Court of Appeals, and when the court reviewed the record, what they saw was ACU's payment to Chase was done too early. ACU is the subordinate lender. They are not supposed to step on his cure period, which they did. They made the payment early. In addition to that, they sent a letter to Chase saying the specific reason why they were making the payment, it wasn't for refinancing, it was to protect their interests. And at the time they sent the payment, their interest was not in jeopardy. The interest loan was not in default. So they should not have made the payment, but they made the payment, and we contend that that is breach of contract because the payment was made too early and the payment was made when there was no default, as you just said.
Wait a minute. Everybody agrees there was no default. Is that right, counsel for Chase? The default was cured, right?
Right. On April 26, 2013, the default was cured. Your Honor, if I may just say one thing, we're here on a motion for summary judgment. A lot of the facts that plaintiff is explaining in his narrative now are not part of the record. He did not submit an affidavit in response to Chase's motion for summary judgment. A lot of the factual assertions in that brief are not supported by evidence that is in the record. And so while I'm happy to have this conversation with the court about the facts, I would like to remind the court that what we're really talking about here is what the evidence in the record is. I also am not sure if the court can see, I believe, Catherine Gibson's screen, but it seems like there is a presentation here that Chase has never seen that's not part of the record, and we would object to the use of this presentation on this motion.
I want to make sure I understand. The loans were in default to both the credit union and Chase.
Yes, Your Honor.
And Chase was made current. The loan to Chase was reinstated. So we're not talking about any stepping on a cure period because the cure had been made. The loan is current, default is cured, and then the credit union is under the mistaken assumption that the Chase loan is in default, which it wasn't. But you're telling me, counsel for Chase, that they can let any subordinate lien holder pay them off at any point in time whatsoever.
That happens, yes, Your Honor, that happens all the time. Think about a refinancing situation, or a homeowner just sells his home and the mortgage gets paid off as a result of that process. So yes, Chase provided undisputed testimony that it accepts payoffs. It does not investigate what the reason for the payoff was. If the check is sufficient to cover the outstanding balance, Chase will apply that to the loan and will release its security deed, and that's what happened in this case.
And Your Honor, this is Kim Sheridan on behalf of Associated Credit Union. I would like to correct a misstatement that has run rampant throughout this conversation, which is that Associated Credit Union paid off the loan without providing adequate notice to plaintiff, to Dr. Roberts. ACU acted at all times under the terms of its security deed, and it is not required to provide written notice under the terms of paragraph 5, but it did anyway. It provided written notice to Dr. Roberts of this payoff pursuant to correspondence from its counsel that was dated April 26, 2013, which was approximately 4 days prior to the payoff. Now, in addition to the security deed, related to this HELOC, there is also a home equity access note. That note, which is a part of the record, which is a part of Dr. Roberts' transcript, Exhibit 16 and entitled Statement of Agreement, contains in section 16, paragraph 16, notices. The notice required by this paragraph to be given to you or any other notices required shall be deemed properly given and received by you when the credit union deposits said notices in the United States mail, postage prepaid and addressed to you at the address last used by the credit union to communicate with you regarding your account. So, Your Honor, there is no dispute that ACU provided timely notice pursuant to the terms of both the security deed and the accompanying note.
Ms. Sheridan, you agree that the credit union agreed with Chase that we could put everything back the way it was,
Yes,
and it was rejected.
that's correct. In fact, Your Honor, ACU was the first entity to try to make that happen. ACU sent correspondence to Chase saying, we paid this off, not understanding that the reinstatement had been made. Let's work together to unwind this transaction. That was ultimately rejected by the
And I
plaintiff.
assume it was rejected because the plaintiff wanted the higher interest paid and the attorney's fees and all that paid back. And I
That's correct,
assume
Your
that was the deal breaker.
Yes,
Your
Your Honor,
Honor,
that's correct.
I'm sorry to interrupt. Your Honor, James Deering, Your Honor, that's not completely true. The reason why the deal never was struck between ACU and Chase is because a dispute arose, and you can look at Exhibit 29, Plaintiff's Exhibit 29, I think that's been submitted already, that deals with a dispute between Chase and ACU regarding the amount that was going to be paid by Chase back to ACU. The amount, as we know, originally was about $265,000. When the conversation, or when it became apparent that this thing needed to be unwound with regard to that amount, ACU attempted to collect from Chase about $337,000. And therein, and I think it's up on our timeline, that's when the problem became apparent. And I think it became apparent that ACU and Chase were not in agreement as to what was in fact owed. That's why the deal sort of fell apart. With regard to Dr. Roberts could not at a certain point after the amount of time that had passed, could not agree to the terms and conditions that were being put forth by ACU. Increased interest, his payments went up almost $1,000 each month. So we're not talking about just an even exchange and a timely exchange. We're talking about two large entities that are actually arguing over who owes what to whom. And Mr. Roberts, or Dr. Roberts, was sort of left in the middle and squeezed by these two. He never received any help. He never received any correspondence. You'll see throughout the documents that have been submitted that Chase had no intention of unwinding this deal, and that ACU, despite notwithstanding what Ms. Sheridan says, did not provide adequate notice. We're talking about 3 days before an actual payoff. That is not adequate notice. And we're not sure that that notice was actually received by Dr. Roberts. I don't know. I think there was some question about whether.
I'm sorry for interrupting you, Mr. Deering. I don't know that it's required that it be received. That's not what you're saying, Ms. Sheridan, right?
That's right. It's not required to be received. Under paragraph 16 of the home equity access note, it says that notice is deemed to be properly given and received by you, with being plaintiff, when the credit union deposits the notice in the United States mail. And the parties can contract as to that term, Your Honor.
How much was the original first mortgage to Chase?
The original first mortgage to Chase was about 220, I want to say 220, 265 to 255.
What was the interest rate and the monthly pay? What was the interest rate and how long was the loan? And what was the monthly payment?
The interest rate was 5%. The monthly payment with taxes and insurance was $24,2073 to Chase.
Okay. Now, 5%. Obviously, the second was an adjustable rate. And so the average payment on that was $863, is that correct?
Average, yes.
All right. How long was the second mortgage, Ms. Sheridan, to the credit union? And what was the principal, please?
I don't have the term of the second
You know, Ms.
mortgage.
Gibson?
The principal was 100,000. He didn't draw down the full 100. I think he was at 88,000, and it was a 30-year as well, adjustable.
Okay.
So his total monthly payments were $3283.73. Keep in mind, Judge, he's at the end of his career. He wants to vacation and enjoy his practice. He's winding it down. And then he gets hit with this scenario. His mortgage goes up $1,300 a month. He can't help his daughter with college. He has to start taking more active role in the practice of his medicine career. And he's been doing this, begging them for 14 months. 14 months. Finally, he has to hire an attorney and file suit. And they want him to come to the table with 18 grand. Plus, he's already been paying all this additional interest for all these months. Going back and forth with them on the taxes. So that's why the deal fell apart. And as Ms. Sheridan says, that the notice is given and received when it's placed in the mail, but they say they sent it for certified mail. They've never presented any proof of that. So that's a question of fact as to whether they sent the notice to Dr. Roberts. We don't have any proof that the letter was sent. We don't have a certified mail receipt that it was sent. And so all we have is the letter itself. And
I'm sorry, that's not accurate, Your Honor. We have an affidavit submitted in connection with our motion for summary judgment that addresses and avers that the certified mail letter was sent and received. And in fact, in Dr. Roberts' deposition, he never denied receipt. He just said it was so long ago that he cannot recall. And he was specifically asked whether he had any reason to believe that he did not receive it. And he said, well, I'm not sure, but even if I did receive it, it would have been later than the time of the payoff. So this whole dispute about whether or not ACU gave proper notice is a red herring. They gave appropriate notice under the terms of both the security deed as accompanied by the note.
Is there any hope?
Your Honor, excuse me, James Deering, in response to Ms. Sheridan, I mean, that very explanation that given by Ms. Sheridan, it is proof that there is a genuine issue as to a material fact about notice, whether or not the notice was actually sent, whether it was received. It is always better, Your Honor, in a situation like this, to let a jury decide, did the notice was it in fact being sent? She's saying that instead of producing a green card, for example, she has an affidavit. I mean, that affidavit weighs no more than with someone coming in and saying that, or having a green card to prove otherwise. I mean, that we are talking about a central point that they are contending did occur based on an affidavit. They are a large record-keeping organization, Your Honor. We can only base some of what we have off of the records that they provided, not their testimony based on an affidavit.
Your Honor, it was sent, it wasn't required. First of all, it wasn't required to be sent via certified mail. It was required to be sent via US mail. It was sent via 2 separate methods in order to ensure receipt. And Your Honor, this is absolutely the type of issue that is ripe for a motion for summary judgment. YC Development versus Norton 344 Georgia App 69 speaks to this very issue. And in that case, they held that because the parties had agreed prior to the issue in the documents as to what notice was to be given, when there was evidence that a notice was given pursuant to the terms of the contractual agreements, then judgment as a matter of law was right.
Let me make sure I understand this. The loan was brought current, the Chase loan was brought current. The credit union didn't know that.
Did not,
Paid the
that's
loan
correct.
off. Is that correct?
That's correct.
And the
Yes.
credit union didn't know that. The credit union paid it off. But the credit union sent the notice you're saying, I assume regular mail and certified mail.
Yes, Your Honor.
And did we get a signature by the plaintiff on that? Or we don't know?
I don't know,
We
Your Honor.
don't,
They don't have.
we
the
don't know.
card.
Okay, but the document says as long as you send it to the address that's known, the property address, that
That's
it's
correct.
deemed received.
That's correct.
We
But-
don't have any proof that it was sent.
But the affidavit says it was sent. And you've referenced the deposition testimony of Dr. Roberts wherein he doesn't deny that he got it. There's
Correct, Your Honor.
some wavering. All right, but he doesn't deny that he got it. But you're telling me, Ms. Sheridan, that as long as you sent that notice, you could have paid that loan off in January, March, June, right?
Yes, yes, Your Honor.
You
Well,
could have done that. You could have done that voluntarily.
well, that's not what the terms of our agreement say. Our security deed says that we can act to protect our interests in the property. And that's what we did, because at the time we were completely unaware of any reinstatement by Dr. Roberts. So as far as ACU knew, the property was about to be foreclosed upon by Chase, which meant that its second was going to be extinguished. In order to avoid that, that's why ACU acted to protect its interest in the property at issue.
Now, is ACU in the business of first mortgages?
They can at times, yes, Your Honor.
I mean, but let me see if I can phrase my question better. You do have a first mortgage now because you paid off the first mortgage, right?
Yes, Your Honor.
But are you normally a credit line business where you have a second mortgage?
ACU is a business that has second mortgages. They offer home equity line of credit as a part of their business.
Is there any way that ACU would refinance this mortgage you have to try to settle the case?
ACU attempted to do that from the beginning. And in fact, they attempted to offer Dr. Roberts a fixed rate mortgage, and Dr. Roberts denied that offer because he did not want to pay closing costs in connection with the refinancing of his loan.
How much of the closing cost?
They asked
Yeah.
for $18,000 and it was a 15-year mortgage. So the mortgage terms were not equivalent to what he had with Chase. As you
Is there
said,
any hopes of negotiating a refinance with ACU that would resolve this case? I mean, we got to realize that is ACU still interested in trying to accommodate Dr. Roberts?
ACU has made settlement offers, confidential settlement offers to Dr. Roberts, but I have not asked my clients specifically whether they would be interested in refinancing the loan at issue, because frankly, Dr. Roberts has not put that option on the table throughout the course of this litigation.
All right, Mr. Deering and Ms. Gibson. Ms. Gibson, can you hear me?
I can. Yes.
I want you to go back to your client and tell your client that he's got an opportunity to try to negotiate with Miss Sheridan a better situation with the credit union than he has now. And Miss Sheridan, we understand what the situation is currently with the credit union's loan, and you're willing to offer something better than he has now, right?
Your Honor, I don't have authority on behalf of my
understand that.
client, but I will absolutely immediately request that they consider refinancing. However, Catherine, you can probably speak to this better than I can. Has Dr. Roberts taken some action to move his loan or?
To refinance it, yeah, because this case has been going since 2014. And it's now, he had to file bankruptcy as well. They almost sold the house. It's been a lot. And so he has like 80,000 left on it. And I think he went through his bankruptcy counsel. was doing some kind of refinancing of the last remaining $80,000 that was left on the loan. So he's paid from $330,000, he's down to $80,000 at this point at the higher interest rate.
Let's work out a loan for the 80 at a better interest rate and better terms, and let's resolve it.
Judge,
Your
can
Honor,
I say one thing?
Yeah.
What Ms. Sheridan said was that ACU did not know that this loan was in default, but ACU had ordered its payoff April 17th, and they sent the payoff April 30th, which we say is too early. It should have been sent after May 3rd, but they never checked again. Once they ordered the payoff, they never checked with McCalla-Raymer to see if he brought his loan current. And they talked to him during that time.
Your Honor,
And-
first of all, that's not accurate.
All right, wait. Let me hear from Ms. Sheridan, please. Ms. Sheridan,
Yes, Your Honor.
you were speaking.
Yes, I'm sorry, I didn't want to interrupt, but
No,
that's not accurate, Your Honor. First of all, ACU does not have an obligation once it is informed that the loan is in default and is about to be foreclosed upon, to continue to go back to the lending institution and say, is it still in default? Is it still in default? Is it still
Wait a
in
minute.
default?
When you went in and out, will you repeat what you said about you don't have an obligation?
There's no legal obligation, Your Honor, to continue to check with the lending institution in order to confirm that the loan is still in default, but they did in fact attempt to determine whether or not the loan was still in fact, and all the information that they received was that the loan was still in default, because the payment wasn't made until the very date on which ACU sent its payoff. Like, the payoff was made on April the 30th, and the reinstatement was made on April 26th. And it would have been around that time that ACU was making arrangements for the payoff, which was then sent on April 30th. And so
Chase has no duty to say, hey, the loan's current, we don't want your money. Right?
That's correct. Your
Certainly,
Honor. There are no
Mr.
claims. There are no claims by ACU against Chase in this matter. And I do just want to clarify that there are totally separate claims against the two defendants here. There are two separate motions for summary judgment. The only claims against Chase are the breach of contract claim, which the theory is that Chase was not capable, or should not have been, was not entitled to apply the payoff to the loan. But as we've discussed, the plaintiff has never been able to point to any term of the contract that prohibits that. And then we have the fraud and misrepresentation claims against Chase, which we haven't yet discussed, but fail for numerous reasons. Each element of the fraud and misrepresentation claims, plaintiff has not adduced evidence capable of creating a genuine issue of material fact. In fact, plaintiff has abandoned 13 of the 14 fraud and misrepresentation claims that he pleaded in the amended complaint and stated in his sworn written discovery responses to Chase. And in fact, in response to summary judgment, he's trying to introduce 3 entirely new fraud and misrepresentation claims that were never pleaded with particularity, and were not identified in his sworn written discovery responses as to the basis of his claim. So I don't know if you want to talk about fraud and misrepresentation at some other point in more detail, but I do just want to clarify that this can't just be resolved by ACU trying to go back and work something out with the plaintiff. We did try and mediate this case last fall, and it was unsuccessful, as you know. And so I just want to focus the court on what the claims are here against each co-defendant.
I understand. Ms. Sheridan, if Dr. Roberts came to the credit union and tried to work something out, y'all would be willing to try to work something out that's more favorable to him on the $80,000. And obviously, somebody would not want to refinance a house and have to come up with $18,000 at a closing for $80,000.
Your Honor, I understand. And I would certainly communicate that as I said, I don't have authority from my
And
client.
well, here's what we're gonna do. I've read the entire record. I believe that all of the claims against both defendants fail. I will withhold ruling on summary judgment with, for 10 days, for 15, till June 10th, July 10th, hoping that there can be a deal worked out with Associated Credit Union. So after July 10th, I'd ask Ms. Sheridan and counsel for Chase to submit me orders. Okay, and I hope y'all can resolve it, and I appreciate y'all's courtesies and professionalism. Have a good day.
Your Honor, how does that work with you being reassigned as?
I can still sign it.
Okay.
I can still sign it. Y'all have a good day. Thank you.
Yeah, counsel, do you need to be put into rooms with Ms. Sanders?
Yes, we do.
Please.
Okay, who needs to go?
Kimberly Sheridan.
I'm
Tom
sorry,
Eisler.
it's very hard to hear you. Hold on.
I believe it's Mr. Isler or Eiler, Sheridan.
Yes.
And thank you. Thank you, Ripple.
I'm sorry, I had to ask people to pipe down in the office. Now, I'm sorry, Ms. Sanders, who needs to go?
Ms. Sheridan, I think it's Ms. Sheridan, Mr.
Yes.
Isler, I'm probably saying that wrong,
That's
and Ms.
fine.
Gibson.
James Deere.
Okay.
All I have are these. I know Mr. Isler, I spoke with his paralegal, and I do have 2 forms. This is the reason why you're supposed to circle who you represent, so it's easier at this point in time. But I do have, in addition to Mr. Isler's, 2 more. So if you fill out a form, let me know so we can go into a breakout room.
Okay, so I've got Ms. Sheridan and Ms. Sanders in a breakout room, and who else?
I
Mr.
think my
Eisler.
office in the forms for
Mr.
the,
Eisler, you need to go as well?
We need to make an arrangement for payment, is my understanding.
Okay, let me move you to the breakout room with Ms. Sanders too. Anybody else need to make payment?
Yeah, James Deering, Catherine
Mr.
Gibson.
Deering? Okay. All right. Hopefully I've done that correctly. Candace, are you in there? No?
This is what I'll do. If each side can give me their phone number, because this is credit card information, I'm sure not all of you want to be in the same room. I'm going to just write down each of your phone numbers. Please keep in mind, if you did not fill out the takedown form, it's going to be a little more difficult for you to to fill one out now. Hence why I always like to prepare beforehand. So what I'm going to do is I'm going to ask Ms. Sheridan what her number is so I can call her.
Yes. 770
Mm-hmm.
778
Mm-hmm.
6052.
Thank you. Mr. Isler?
203-494-1927.
27. And Ms. Gibson?
404-733-6700.
All right, I should be calling all of you guys shortly. Give me about 10 minutes probably in between everyone, but I'll make sure that I will call you. So just be on the lookout for a 404-612 number.
Do you have my number? This is James Deere. You have my number?
Did you fill out the
404.
form for takedown?
Oh, no, we'll,
No, I think,
for our takedown, James.
okay, that's fine.
And that's usually how it works with the transcript. If you don't pay for takedown, you can't get the transcript. Not a big fan of those sharing transcripts because then you're cheating the poor court reporter out of money. But I will call you guys shortly. I hope you guys have a lovely day and thank you for speaking one at a time.
Thank you for being patient with
Thank you.
my technological shortcomings.
You guys have a good day.
Thank you.
You too.
Catherine, I'll call you.
Thanks.